Hi, I'm Alex. I'm one of the A-level law teachers. Today we're going to be looking at criminal law, in particular non-fatal offences and assault. So, what is an assault? When we look at the papers, we often see an assault as some kind of physical altercation. A case that came about a few years ago was the girls' loud singer Cheryl Cole was in the paper for assaulting a toilet attendant. She punched her during a bit of a scuffle in the toilets in a nightclub in London. Naomi Campbell, something really similar, was kicked off a plane by flight attendants. Police had to remove her and she assaulted a police officer, she slapped him. And then more recently we've seen the case of Will Smith and Chris Rock at the Oscars. When Will Smith went on stage and slapped Chris Rock, it was deemed to be an assault. But that's not actually the case. Assault isn't a physical altercation. We're going to look in more detail at what an assault actually is. So, an assault, it's a summary offence. It means it's a minor crime. It's the least most serious type of a non-fatal offence. The maximum sentence a judge or magistrate can give an offender is 6 months imprisonment for that offence. The main elements of the offence have been defined by cases that have gone to court. So there's no piece of legislation, there is no law that actually governs what an assault is. However, when you are being arrested, you are charged under Section 39 of the Criminal Justice Act. So, an assault, it's an act which causes the victim to apprehend the immediate unlawful violence. The defendant intends to cause the victim to fear immediate unlawful personal violence or is reckless as to whether fear is caused. So all this means is that the victim is fearful of something. The defendant has done something or said something which has caused the victim to fear. The defendant either intends to cause the victim to be fearful or is reckless. Their actions have been so reckless that the victim has feared for their safety. So, an assault. An assault can be committed through an act or gestures, swearing at someone really aggressively potentially, or words. The words can be written or verbal, and silence can also amount to an assault. The focus is on what the victim actually felt. So, we look at not what the defendant intended per se, but we look at what the victim thought was going to happen, and that is key to whether an assault has been committed. There are many examples of an assault. So, raising fists at someone as if you're going to hit them, pointing a loaded gun at someone within range, and making a threat such as "I'm going to hit you." All of these things amount to an assault. Fear of any unwanted touching is also sufficient. So if you're fearful that someone's going to touch you, that someone's going to invade your personal space, that can also amount to an assault. It doesn't need to be serious. So your fear what they're doing doesn't need to be serious. As long as you are fearful, as long as you apprehend some kind of immediate unlawful personal violence, then that's sufficient for an assault to have been committed. In the case of Ireland, 1997, the defendant made a series of silent phone calls over 3 months to different women. And this case was way before caller ID and before you could block people's numbers. So all these women were fearful. Who's ringing? Who's being silent down the phone? When they eventually found out, the defendant was found guilty of an assault. And this is how we now know that silence can amount to an assault. The defendant in this case made the victims apprehend, made them fear immediate unlawful violence. The most important factor is that the words or act causes the victim to fear, to apprehend, to anticipate some kind of unlawful personal violence is going to occur. Immediate force, they just need to fear that immediate force could or would be used against them. There is no assault if the situation is obvious that the defendant cannot actually use the force. So what that means is if the defendant shouts abuse at somebody on a passing train, it's obvious the defendant cannot carry out the act there and then, therefore no assault has been committed. Fear of immediate force is necessary. Immediate does not need to be instantaneous. As long as they apprehend something fearful in the immediate future, that's enough to satisfy it. And in theory, an assault can also be committed through a closed window. In the case of Lamb, 1967, 2 boys were playing with a revolver. There were 2 bullets in the opposite chamber of the bullet, and the boys believed that this meant the gun wouldn't go off. One of the boys then pointed the gun at the other boy and pulled the trigger. The chamber turned, the gun went off and it killed the boy. What I'd like you to do now is just have a little think. Do we think that that's an assault? The defendant was found not guilty of an assault, and he was also found not guilty of unlawful act manslaughter. Even though the victim died in this case, there was no apprehension. Both the boys in this case firmly believed that where the bullets were positioned in that gun, the gun wouldn't go off. So there was no apprehension. There was no fear from the victim in this case that when that gun was pointed at him, he was going to die. So no unlawful act and no assault had been committed, as the victim did not believe the gun would go off. Therefore, he did not apprehend immediate unlawful personal violence. In the case of Smith and Chief Superintendent of Woking Police Station, the defendant broke into a garden and looked through the victim's bedroom window on the ground floor at 11 p.m. one evening. The victim was terrified and thought that the defendant was going to enter her bedroom. Although the defendant was outside and she was inside, she was still fearful that an imminent attack would occur. The defendant in this case was found guilty of an assault. Now, if you go back a couple of slides, I said that an assault can still be committed even if a window is closed. The defendant had options in this case. If he really wanted to, he could have broken a window to get into the victim. He could have broken down a door. So an assault is satisfied so long as that victim apprehends immediate unlawful violence, which is what happened in this case. An assault satisfied. All he did was stand and stare, but that was enough to satisfy it. The basis of the victim's fear was that she did not know what the defendant was going to do next, but was likely it would be that of a violent nature. Fear of what the defendant might do next was sufficiently immediate for the purposes of this event. No one had any idea. Was he going to break in? No one knew. The focus is on what the victim thought, and the victim thought she was in immediate danger, and therefore an assault was satisfied. In the case of Logden and DPP 1976, the defendant pointed an imitation gun and told the victim he was going to be held hostage, and the victim was terrified. In this case, the defendant was found guilty of an assault. He made the victim apprehend immediate unlawful violence, and the defendant was reckless as to cause him to apprehend such violence. So this is just a snippet of what we're going to cover in A-level law. If you want any more information on law and A-level law here at Huddersfield New College, just go online and you'll find more details.